definitely that will have a negative impact. Look at the price of food. The price of food increases. The school fees increases. Petrol increases from time and again. And that has really caused a strain on our membership because as it is being used, this is the very first time where employer did not want to implement an agreement or the last leg or any leg of an agreement that was concluded within the PSCBC. In the history of collective bargaining under the PSCBC, this is the very first time where, as an organization, SAPU, where we have to deal with a situation where an agreement is not implemented, even though it has been concluded. So, the effects, the negative effects that our members are still feeling, now we are in the month of September. They are still suffering because adjustment was not made from the 1st of July, 2020.
Thank you. This is, from what you have given, this is quite, I think, to use the word unfortunate, can be seen to be an understatement. It's quite tragic to our members. But now, one of the things that I needed to ask you and get clarity on so that the members can also get clarity. What was the employer's reasons for unimplementation? Is there any reasons that they forwarded to you as Labour Party?
You're asking a very good question, very legit question. We find ourselves now being under the stage of disaster because of COVID-19. That's where, as a country, we find ourselves. Going back to the issue of COVID-19 as well, to say, when did it start? It started to develop further, around February, March. That's where the momentum came and we experienced, the declaration of the President of the Republic of South Africa declaring the lockdown as on the 26th of March. But the intention of the employer or the DPSA, it came into play even before we could know that there is an existence of COVID-19, of a virus or a pandemic called COVID-19. So the employer had that intention from late last year in 2019, where they brought to the PSCBC their intention of not wanting to implement. And as a Labour there, we said, no, employer, you cannot do that. You proved yourself by concluding an agreement and implementing 2 legs of that agreement. Now you want to walk away and not implement the last leg. As Labour, we were not prepared and we will never ever be prepared. From the side of SAPU, we will never even be prepared to let our members suffer from something that as a union we went there in good faith and negotiated for the benefit of our members.
Of course, what you are saying indeed, from the ordinary man's understanding point of view, it is clear that it has brought a discomfort amongst the members of the trade union.
That is true.
It has brought a lot of discomfort amongst them, and their families suffered because most of the members actually they plan around their increases. They've got plans that they take in what is it that they want to achieve at the end of this year, and then that includes the increment that they are expecting from the employer.
You're correct.
So now the question that I have, and I think members are eager to understand here and they need clarity here. As a union, as SAPU, what is it that you've done upon realizing that the employer is not intending to implement Resolution 1 of 2018?
Remember from the PSCBC, as SAPU, we are admitted there. We are an admitted trade union in terms of the threshold. And when we realized that indeed employer has this intention, together with other unions, we lodged a dispute because it is good that we bring it forth to say there is a certain procedure that one has to follow, or that a union has to follow when they are not in agreement with what the employer is bringing, or if they are in deadlock and there is no way forward. SAPU, together with other unions, lodged a dispute. That dispute went through conciliation. That conciliation was held virtually during the lockdown. And that conciliation itself, it took weeks and weeks. And what the DPSA was doing, they were just going round and round, going round and round. Even when the conciliators who were appointed by the PSCBC to oversee and direct the process were trying to bring the parties together to one another, the employer did not budge. And at some stage, they then used the COVID-19 as an excuse to say they do not have funds because of the COVID-19. And mind you, their intention was clear even before COVID-19 pandemic could come into play. And from the conciliation, when we realized that this conciliation is not bearing any fruits, it is not going to assist our membership, because as SAPU, what matters, it is what is best for our members. Then a certificate of non-resolution was signed, meaning that the matter was then referred to arbitration. And now it is good that we bring about to say, here we have a legal binding contract in a form of a resolution. And the part of it is non-implementation. Employer, even during conciliation, they agreed that that agreement is valid. It is a valid agreement. They agreed that there is nothing wrong with the agreement, but it is just them who want not to implement the last leg of the agreement. So, as SAPU, through our participation into the conciliation up until the certificate of non-resolution was issued, we were hoping to say conciliation on its own, it would be able to resolve. Because in conciliation, you know, there are side meetings that commissioners hold. But those side meetings, they never assisted. The status quo from the employer of not wanting to implement the resolution remained. And when the matter was referred to arbitration, SAPU took into cognizance or took, you know, into play or into consideration the issue of saying that here we are looking for the implementation of the agreement or the last leg of the agreement. What will the commissioner do to assist that this gets implemented? Because when you refer, you know, at PSCBC, there is no, it doesn't even give you space when you fill the referral form in terms of the implementation, but it speaks of the interpretation and application of a collective agreement. And looking at, this is a contract, then as SAPU we realized to say, arbitration will not be able to assist us. Thus, we then withdrew from the arbitration process and then joined hands together with other unions. Then we went to the labor court, where we believe that now we are not seeking for an award. Because anyway, the DPSA agrees to say the agreement or the resolution is a valid resolution. There is nothing with it. So all we were seeking, it is to say, let us get something that is binding from the court to say the implementation of this resolution should be done. And we did that realizing and, you know, having that conviction within ourselves as SAPU to say, when we approach the labor court, we would be able to succeed. We looked at the prospects of success to say, there we would be able to manage and be able to succeed.
Look, we hear you on the steps that SAPU has taken. But then there's something that I would like the members to know of. You mentioned the issue of SAPU being engaging in conciliation. And then during the conciliation, where the employer, which is the TPSA, where you said that they never came forth straight, they kept on diving from side to side. Were members aware of such? Was SAPU continuously giving feedback of such meetings to the members?
Remember, as SAPU, we are carrying a mandate of our members. SAPU is an organization that takes mandate from its members. And from time and again, feedback that came from those conciliation processes, as SAPU, we have a responsibility to give it out to members. And we have duly done that. And even as we speak currently, we are still doing the same because our members, the mandate they gave us with this resolution, we even specifically issued mandate forms that speaks to the increment, the implementation of the PSCBC Resolution 1 of 2018. So that interaction with our members, we received thousands and thousands of those forms completed by members and giving us a mandate to say, yes, you must proceed with this matter and take it to court.
In a nutshell, you were saying that SAPU continuously gave feedback of the meetings from the members. And the reason why you ended up taking the route that you took of taking this matter through to court instead of an arbitration, was it because you also got a mandate from workers?
That is true. We have those forms. We have thousands and thousands of those forms. And even as we speak today, some they keep on coming in, strictly because our members out there are frustrated by this non-implementation of this resolution. That is why as SAPU, the matter, it is at court because we are following the mandate that we were given by our members.
Look, I would like to get legitimacy on the statement that you are saying the members are frustrated. What have you seen to see that the members are frustrated? Or do members come in walking through to SAPU offices, or is there any form of communications that the members are using to communicate with you?
Remember, as SAPU, we aligned ourselves with the fourth industrial revolution. And we've got different means that we use to communicate with our members. Some of those means, even those mandate forms, we have them on our app, on our SAPU app, where our members are able to chat with us. And those frustrations, they are being ventilated there, even through the app. We've got our social media platforms, our Facebook, our Twitter, even our Instagram. Our members, they keep on daily, expressing their frustrations. And as a union, we take cognizance of the frustrations that our members are facing. Thus, we are pushing for this matter to be heard as soon as possible within the labor court so that this can be implemented fully and our members can benefit what is due to them. So we are in communication with our members. We are in communication with them. We give them feedback. We hear what they say through those platforms. They speak to us day and night. And we appreciate that so much. That interaction that we are receiving through all this communication means that we have created as a union for our members.
So currently you are saying that the matter is at labor court. However, there has been reports in the media that the matter is still at arbitration. Can you clarify the members based on that? Because the media reports have been reporting that the arbitration is still ongoing, and the others are saying the matter is at court. Can you clarify on those two processes? Because some of the members might be confused because the member might think that the matter is at arbitration, some might think that the matter is at labor court. Can you clarify on that?
It is good that we bring it into the know of our members. We bring it forth to our members to say, at PSCBC, there are those, who are in a block of another federation. And there are those unions that are independent there at PSCBC. We're talking about the composition of PSCBC. And SAPU, it is the one that is sitting there as an independent union. And those who fall under the other federation, they are the ones who were at arbitration. And SAPU, inclusive of other unions, then went to court, and we are still at court. But it is good to bring it forth to say the DPSA, when the arbitration started, they even, went to an extent of even stopping that arbitration at court, to apply at court for an interdict to say it should stop. Up until to an extent whereby, as we speak, even those other unions, they are to join those that are already at court, because the argument that SAPU had and mandated by its members to say the best place or the best platform where jurisdiction is there to hear this matter, it is at the Labour Court. So the matter, it is at Labour Court. It is just that others participated at the arbitration, which we foresaw that it would not bear any fruit for our members. Instead, it will cause a time delay, because the DPSA would have to go in arbitration, and that is what they argued in their papers, to say this matter is at court. There are other unions, inclusive of us, the SAPU, who are at the level of court. And then others, they want to subject them at arbitration. Why can't this be done at the level of court? That's where we are as we speak.
As we are in court on this matter, as we have just stated, what is it that we are left with in court? Are we waiting for a court date, or is there any other process that should be followed?
Maybe it is good, to also bring it forth so that we can give information to our members to say, how does the Labour Court works? When we took the route of court, together with other independent unions, at court, the procedure there, it will require you to file papers, and then the employer, the DPSA, representing the employer, also file, and from the side of the unions, they also do replying affidavits as well. So that has been a process that we embarked on. And that process on its own, it has time frames. Unfortunately, comrades, it is not an issue where you just come in, you file today, and then tomorrow, then, a matter is heard. It is a process that we know, it may take some time. But where we are standing now, to answer your question, I believe, I believe that I had to start a little bit with giving this background. And as it stands, all the papers were filed. All answering affidavits are filed. And as we speak, the replying affidavits that were done also by all those who are in court, including us as SAPU, they are filed. All that we are waiting for, we are waiting for the registry to confirm a date, to say when will this matter be heard, and arguments, when can they be made in front of the judge. That is where we are.
Okay, thank you very much. Members, you have just heard from the chief negotiator himself, Mr. Lisiba Tubakale, explaining the process from the beginning up until now. But now the last question that I have for you now, and which you have spoken about, and I would like you to reiterate on, is there any prospect of success in this matter?
As an organization, we are quite an organization that is very well equipped. As we speak, we have been represented by lawyers at the Labour Court with this matter. And before a matter can be taken to court, our lawyers, they have a responsibility to look at the prospects of success. And now, before we speak about the prospects of success, it's good to go back and say, this is a resolution that it has three terms. It has three legs. The first two legs are implemented. And we believe to say, as employer was able to implement the first two legs, it showed that indeed this resolution, they signed it being conscious, they were sober when they were doing that, and they have a responsibility to ensure that the last leg thereof is implemented. So we believe that when we make our arguments in front of the judge in the labor court in Braamfontein, after we receive the date, we believe that, you know what, the judge will rule in our favor to say the DPSA implemented the last leg of this resolution because we've done our homework and clearly we have that conviction that we are going to win so that our members can be able to benefit, even though it has taken a little bit longer, like from July up until now, from the time when members were supposed to have received the increment.
Thank you very much. Lastly but not least, because I think the question is critical, looking at our social media page, the people are concerned about one thing in large, which is when is the court date? Can you briefly clarify on when is the court date? Or is there anything that controls the court date as to when is this matter going to sit? Because they've had to explain from the beginning up until now that the matter is in court. When is the court date? Do you have that information as SAPU?
That question, as it stands, we cannot confirm the court date solely because we do not have a court date as yet. But through our lawyers, those who are representing us at the labor court in this matter, they are working closely with the registry at court, finding out from time and again to say, when can this matter be set down? And as an organization, that is the responsibility we are carrying. And we will ensure that as soon as we receive that court date from our lawyers, when the registrar at the labor court issues that court date, we will populate it in all our spaces so that our members can know that when is their organization, SAPU, going to the labor court to represent them, going to the labor court to force the employer to implement this resolution.
Thank you very much, Mr. Tubakale. You've heard it from the chief negotiator. The information was so thoughtful, and then everything has been that I have queried. I was being guided by the social media contributions that have been coming on from different people. I think we are about to close. Actually, we are closing this topic, as Mr. Receiver Tubakale have answered my last question. That was been also, as I've stated, being driven or being asked from our contributors or our participants in the social media. The second topic that we would also address it
excluded members of the SAPs. And remember, members of the SAPs are the ones who are in the front line in terms of dealing with crime. They are the ones in the front line in terms of attending to complaints, in terms of being involved in shootings, in terms of escorting prisoners, in terms of visiting prisoners and feeding prisoners in the cells. It doesn't need a rocket scientist to acknowledge and accept that members in the SAPs, they qualify to have a special danger allowance. So that resolution of 2015 excluded members of the SAPs. And currently what SAPU has done from the SPC, PSCBC, through negotiations, we pushed for the door to be opened in order to acknowledge and include other categories within the SAPs. And that window, when it opened, it went to sectors. And in our case, it went to the SSBC, which is a sector that deals with issues that comes from the SAPs. And through the SAPU, we included everyone who works in the SAPs to say they do qualify for the special danger allowance. And we'll give an example to say, you will find that a Public Service Act personnel drives a marked police vehicle with a P or with a normal number plate. But when criminals see that, they see a police. If they shoot, they will shoot. They don't even ask a question. They won't even ask a question to say, are you a Police Act member? Are you armed or not? But that on its own, it brings danger to all our employees, inclusive our data capturers at the CSC. When a police station is under attack, when those criminals come in there, the issues of Eto was a clear example. When they come in there, they don't ask. All they do, they shoot because they want whatever they want from them. So through that window that was opened by the PSCBC, we then submitted to say, everybody, all categories within SAPs, they are to be considered to receive this special danger allowance. And as we speak, it has moved from the SSBC because categories are then submitted. It is at the PSCBC, whereby a draft agreement was drafted by labor there, and it was given to the employer just before the lockdown to come back with a mandate to say, we want to see that being realized. And negotiations on it are still proceeding further. And SAPU will not stop up until it sees that our members are benefiting in terms of the special danger allowance.
Thank you very much, Mr. Nsiba. In your presentation of the second topic, you spoke about the special allowance, this SAPS, that it's something that has been there. Is there any payment thereof? And if ever there is a payment that is thereof, how much is it?
The service allowance that I referred to is 400, and it has been 400 for some time as we speak. That is why at the SSBC, we took upon from labor to say we need to push the increase of that allowance. It needs to be linked with the CPI. And as we speak, we tabled a resolution or a draft that speaks to increase that service allowance to 1,500. And we are taking into consideration all these other years that were lost because it was supposed to be adjusted in terms of the CPI. And when we did our calculations in accordance to where we are currently, 1,500, it is it is a better amount. We can't say it's the best amount, but it is a better amount, which we hope and believe that the employer will come into party in this matter. And when they do so, it will still be adjusted annually in terms of the CPI.
No, thank you very much on that one, because I think members needed clarity on that they must know that there is some allowance that members are getting, and there is a danger allowance that SAPU is pushing that all the SAPS members must get. I think you have clarified that issue. We'll now move into the third issue, which is the incorporation of Public Service Act employees into the Police Act. I think on this issue, in SAPS, we've got members who are employed in terms of the Public Service Act, and then we've got members who are also who are employed in terms of the Police Act. So this incorporation, I think it suggests that the Public Service Act members whom we refer to as the PSAT or the PSA members needs to be incorporated into Police Act. Can you take us through on that?
True. This emulates from the SPC Agreement 2 of 2011, the Part D thereof, the 5.2 of that agreement, to say parties there at the PSCBC, together with the National Treasury, they will work on mechanisms that will realize the incorporation of the Public Service Act members into the Police Act. And the rationale thereof, it was to say, as it stands, discipline, when it is being done, it is being done in terms of Disciplinary Regulation 2016, which include Police Act members and also Public Service Act members. And as it stands, as an organization, SAPU, we believe that we have one Minister of Police, but under the Ministry of Police, or the department itself, South African Police Services, we have members who belong to the Minister of the DPSA, according to their classification of act. And that on its own, it brings inconsistency in terms of the benefits that these employees or these members are supposed to enjoy. I would love to highlight a little bit to say, if a member is under the Public Service Act, the pension contribution of the employer towards his or her pension is 13%, whereas under the Police Act, it is 16%. That 3% ratio on its own, it makes a big difference. So, as SAPU, we are championing the incorporation of this Public Service Act personnel into the Police Act. And as I've stated to say, it comes from 2011. There has been issues that related to the change of national commissioners during that, the transition thereof, as from 2011 even up until currently as we are. And that politically, it had a negative impact in the realization of this incorporation. But as we speak now, as SAPU, we are spearheading it in the next negotiations that are proceeding from the 29th of this month. We want the employer to come to party and conclude the issue of this incorporation so that we can have one minister, one act, one national commissioner, and our members can enjoy these benefits. And we're not saying we are making our members to be police officials, but we are saying let us have a stream of administration within the Police Act so that members can be able to enjoy Parliament and come out of the gems, which is tailor-made for all the general public service, and for them to come into Parliament and enjoy it as it is a defined benefit, which is only meant for members who are under the Police Act. And we want to assure our members who are under the Public Service Act to say, we know this matter has taken long, but SAPU, we are hard at work, and we are not going to rest up until we see the realization of it. If we have to push harder than the normal way that we push in council, we will have to do it. If our members have to go to the street, because the LRA allows them to do so, as they are not classified as essential services, we are going to follow that route. Any route that is going to put pressure on the employer to realize this matter, we are going to follow it, because this injustice, we want to correct it. And we are not going to rest as SAPU up until we correct this injustice that has been done to our Public Service Act personnel.
Look, thank you. You have touched on the issue of essential service. I mean, looking at this issue of essential service, for example, during the first round of lockdown, the police, operational police in police stations, were working normally because they are an essential service, which I believe they are part of the Police Act. Now, we've got the Public Service Act members who were also working during that time. How is your take on that? Isn't it a double standard whereby SAPS is only recognizing these members of PSAP as essential when they need to do so, but then if it doesn't fit them, they don't recognize them?
You're correct in what you are saying. Some of the Public Service Act personnel were required to work during the first lockdown that had started on the 26th of March. Clearly, because the Police Act members cannot function without the Public Service Act personnel in terms of the duties that they are performing, the support duties that they are performing or that they are giving to the Police Act members. And you are correct to say the employer has double standards. When it suits them, those Public Service Act personnel who are not by the law classified as essential, but they were able to classify them and even offered them the service allowance for the 2 months. So through that, it clearly shows that these members, their services that they are rendering is essential, because Police Act members, they cannot operate or they cannot function without the support of this Public Service Act personnel. And that on its own, even that argument, we are going to use it further, even in negotiations, to say, you are able to recognize them there. Then you agree with us, with our argument, to say these members, they are deemed to be, or they are needed. Then let them be classified as essential, but let them benefit as well. Let it be done in accordance to the law by incorporating them into the Police Act, and let them continue to render that those administration duties. And that on its own, it will even allow them, to those who want to do operational duties, because they'll be falling under one act, then they can do the necessary training and become operational. Nothing will stop them. But that injustice and inconsistency by the employer, it is not correct. And as SAPU, we are spearheading to say, let this incorporation come into place.
Looking at the growth paths with two categories of employees, the PSA and then the Public Police Act members, is there equality thereof?
There is none, because when we are looking at the benefits, moreover, them falling under the GEMS medical aid, which is meant for everyone, nurses, our teachers out there, and the rest of the public service, workers. That on its own, they can benefit from the Parliament, which is a defined benefit. So when we look at if a Public Service Act personnel passes on, that amount on duty, that amount of money that a Police Act member is receiving, they do not receive it. And the contribution of the pension that I earlier spoke about, to say this contribution of the 13% for the Public Service Act personnel, but 16% for the Police Act members. That on its own, it shows inconsistency and there is no equality. But as SAPU, as an organization, we are saying we don't want members to fight within themselves because of the classification of which act you are under. Instead, we are pushing to unite members to say, let us have one act. Let everyone have the very same benefits when we go to negotiations, to negotiate in terms of the conditions of service. We can negotiate for everyone so that they enjoy everything in accordance.
So thank you very much for such a mouthful explanation. And ladies and gentlemen, we have come to the conclusion of our topics, and the other topics shall follow. We will continuously be engaging with you as members on all our